Number 72, People v. Hasahn Murray.
May it please the court, Abigail Everett for appellate Hasahn Murray. I'd like to request 2 minutes for rebuttal, please, Your Honor.
You may have 2 minutes.
Under CPL 270-35, when a child judge discharges a sitting juror, the judge has 2 courses of action. If an alternate juror is available, the judge must seat the alternate juror. Otherwise, the judge must grant a mistrial. The issue here is, what did the legislature mean by that word, having an alternate juror available? If you look at the statutory scheme in general of CPL, you'll see that there's a dichotomy, that the legislature makes clear they see a difference between a discharged juror and an available juror.
Counsel, is another way to really put that, whatever available means, and it may mean different things in different contexts, discharge they're mutually exclusive, right? So a discharged juror can't be available.
That's my
Right.
position, Your Honor, yes.
So whatever the overall definition of available for service in another context might be related to something other than discharge, right? Maybe they're late, maybe they're whatever, absent. Discharge, to me, to your point, seems to have a very different application, a different relationship to available for service. And I think those are the provisions that you go through in your brief. You know,
Right.
the death penalty provision, it's discharge versus available for
Right.
service.
They're 2 different things in the legislative view as articulated in the statute. And in fact, you'll also see, it's a little to the side, but the CPLR as well, as we said, talks
Is it
about...
possible to read it that a discharge is a form of unavailability?
Could you repeat that, Your
Is
Honor?
it possible to read it as discharge is a form of availability? Is a subset
Of unavailability.
of unavailability?
I'm not,
Thank
of
you.
unavailability,
Yes,
yes,
my
I think
apologies.
so,
Thank you.
Your Honor. That's correct. And when you look at it from the juror's point of view, they're told they're discharged. That's a very important communication to the juror. How is it, when you retain a juror as available, you continue judicial supervision?
I'm sorry to interrupt you. Let me ask you this. If, just to clarify for myself, to confirm here, the judge discharged, right, the alternate jurors before deliberations started. Is that correct?
That's correct.
If the judge had sent them to deliberate and then had discharged the juror, then, as I think Justice Renwick mentioned, CPL 270.30 subparagraph 1 kicks in, right, where you would not have been able to do this because you've only got 2 options at that point.
Right. The three,
I'm just saying,
270
isn't the problem that in part, that the judge discharged the alternate jurors before deliberations had commenced, and so we're in this place where we're trying to figure out what do you do when 270.30 subparagraph 1 doesn't apply?
Right. I mean, it's not our argument, and that's why there's not a preservation argument, that the error was discharging them before deliberation, before the jury was sent to deliberations. But you can see from 270-35-1 that the legislature anticipated that if the judge makes the discretionary determination to have alternate jurors, that you keep them until deliberations start, because otherwise, and you need consent at that point, because otherwise you're risking a double jeopardy
Could
problem.
you consent to do this? After the jury starts deliberating, you've dismissed the alternates, and the defendant, the same thing happens. But the defendant on the record executes the written document and says, I'm waiving, and I want the alternate back, and they bring the alternate back in the same circumstances we have here.
Well, yes, I think if I'm understanding that, if the defendant waived the provision of the CPL and agreed that the judge could bring the alternate back, then, I mean, it's not this case, but you could have a waiver in that
Counsel,
situation.
quick question about the effect of the discharge. If, as happened here, if before the jury is charged, the judge turns to the alternates and says, you're discharged. Now, somebody with a lot of foresight says, hold on a minute, Judge, that's a really bad idea, because something like this might happen. are there takebacks on that? Can the judge undo the discharge, or is the deed now done?
Well, I think that gets into the whole de minimis issue that was very prominent in the appellate division decision. It's not, I want to make clear, I don't believe what happened here is de minimis because they've left the courthouse and we're talking about a significant amount of time. But there are cases in the appellate division where the judge says discharge the juror, the whole jury, not even an alternate, and the defense lawyer could have said, wait, you forgot to poll them. And the judge could say, oh, yes, you know.
Yeah, but why not leave that to the discretion of the
Right.
trial judge? Isn't the trial judge the best situated person to determine whether someone's available for service, especially if the legislature hasn't defined it? And after a thorough inquiry, isn't it reasonable for us to say to a trial judge, what do you think?
No, I don't
Because-
agree with
Because
that.
if it's a bright line rule, then where is that bright line? Is it after 2 minutes? Is it after 15? Is it once they leave the courtroom, once they leave the outside, the courthouse? Why not just leave it to a judge's discretion, the trial judge?
Because there are a couple reasons. One, it's not fair to the jurors. They're told they're discharged. These are citizens who have been summoned to the courthouse, and they're told they're discharged. They go home, they return to their private lives, and then they get a call from a judge saying, oh, sitting juror violated her obligation. She spoke about the case. Did you do that? Oh, no, Your Honor. The legislature,
Didn't the
it's
judge
in our
ask?
interests.
The judge asked and said, are you willing to come back?
Yes.
And they both
could have said no.
Yeah, they both said, yeah, I can come back.
I know, Your Honor, but
with
as a
respect to
policy.
jury duty, it starts with a summons. You get a summons, and the summons says you're available until we tell you you're discharged. And in this particular instance, this juror had been a sworn alternate, given admonishments about behavior, et cetera. But once you tell a person they're discharged, they're no longer then covered by those requirements.
Correct.
So it becomes rather dicey
Correct.
to say, I can call on the phone and say, come back, and it's okay, just come on back in. No
Right.
harm, no foul.
That would be our position, Your Honor, because it just serves the judicial system better to have clarity so that these lay people who are told they're discharged know they're no longer under court supervision. They can return to their private lives. I'd like to point out, respondent talks about the advantage that's been recognized of leaving things to the discretion of judges, but as Judge Renwick decided in her dissent, that the discretionary determination of whether a person has committed improper conduct is very fact-based. It really is a very important role for the judge to play to determine what happened. Here, you're discharged, you've left the courtroom,
So your
you're no longer
example-
under supervision. You don't need a judge to engage in
So in
any...
your example with that you forget to poll the jury and 15 seconds have elapsed, because the word discharge was uttered, it ends?
That's not my position, no.
Is
My
there room
position
for a
is
de
there
minimis
is a-
exception?
Excuse me.
Is there room for a de minimis exception?
I think there is room for it to be, because my position, as long as they're still in the courtroom, they're still under the supervision of the judge. The judge can see what's happening. It's very different to say, take back immediately.
But isn't that going to lead to litigation over, and I know, preaching the choir here, but litigation over, and I think Justice Sotomayor mentions this in Dietz in a different context, civil jury, but, you know, did they step out of the courtroom? Did they go to the restroom? Did they talk to a court officer in the courtroom? And aren't we going to start to have that type of hearing on, you know, what does it mean to be in the courtroom?
Well, I certainly...
And again, I think this is
because
alternate jurors.
It's certainly not our position that we have no problem with the court having a bright line rule that once the judge says discharge, that's it. But I just am trying to stress that this case doesn't require the court to have that bright line rule, that we are comfortable, if the court seems it appropriate, to have a de minimis.
Thank you, counsel.
I'm sorry.
Go ahead.
I'm sorry.
I don't really understand why leaving the courtroom or leaving the courthouse is a reasonable line to draw for a de minimis exception, if there is to be one, because the regular jurors leave at the end of the day, and the alternates leave at the end of the day.
Yes, Your Honor.
So, I mean,
But there's a big distinction.
Yeah.
When people leave at the end of the day, they're told, You're still under obligation not to discuss the case, not to look at media, not to go to the scene, all those, what is it?
Admonishments.
Those admonishments that are in the CPL.
Right.
That, it's clear to the jurors what their role is. They are still jurors. And that's why we don't require them to be sequestered still. This is very different. They're told, quote unquote, you are discharged. Another is, 6 or 7 years. Often, it didn't happen in this case, but often the judge says, you may
It
go
doesn't really
and
turn
talk.
on where the juror has gone or to what they might have been exposed. In your view, it turns on what they've been told as to
What
their
they've been
obligation.
told. And I would say, just as a policy matter, right, that it does become dicey once they leave the courthouse and you don't know what they're doing. But the bottom line is that they're told they're discharged. They shouldn't have to worry. They can do whatever they feel like. They're private citizens.
Thank you, counsel.
May it please the court, Alexander Michaels on behalf of the people. The trial judge in this case providently exercised her discretion.
So discharge doesn't mean that their obligations of service is over?
Our position here is that that is not an on and off switch. That's a discretionary determination in the same way that every other determination under this particular statutory provision has lent itself to discretionary implementation. The statute, as
So
this court has-
if the judge says come back after 2 days, that's fine?
No, not necessarily. It depends on the relevant functional considerations that apply in this
So the
particular-
problem of the bright line issue that was discussed, it can keep moving further and further away from a question to the juror as to what is my status?
The idea that there's a problematic outer bound here is actually a red herring, because the situation we're talking about is an ongoing trial. And in the context of an ongoing trial...
There is an ongoing trial, but with respect to that juror, I've received the jury summons. It says, until you are discharged. When you're discharged, you're free to go, and it tells you that. So in this particular instance, you're saying it's up to the judge as to when you're discharged? They can take it back at any time?
Well, the idea is that there's flexibility here, the same way there is flexibility in every other provision in that particular subsection of the statute.
But counsel, isn't part of the problem with that argument, I understand it, available for service, you're arguing, look, qualified, judges have discretion, but this court has treated, and the statute treats, alternates differently, right? There are restrictions on alternates, there's our case law tying some of those restrictions to the state constitution, now in the CPL as well, and there's the language that your adversary points to, pretty making clear, in the argument it goes, that discharge and available service are not compatible terms here. So while a jury might get dismissed for 5 minutes and, oh no, we need to correct something, or even a juror, I think is one appellate division case, is in a, wrong, dismissed in error. These are alternates, and we treat alternates differently. The statute treats them differently, and we treat them differently.
When the statute treats them differently, if it wants to create a bright line rule, it absolutely can, and it does so, right? It does treat them differently in the context of when the jury is retiring to deliberate. It creates a bright line rule as to the fact that the defense needs to consent in writing to substitute an alternate at that stage.
Counsel, would you agree that there is no procedure in the CPL for undischarging a juror?
The CPL 270.30 does not get into any of the details of any of these kinds of things.
That to me seems like a pretty strong indication that that's not done. You don't discharge a juror and then, except maybe for some extreme de minimis circumstance, suddenly re-impanel them.
Well, to the extent you want to entertain the idea of an extreme de minimis circumstance, that allows you to consider functional considerations as to what it means to discharge a juror. That sort of approach demonstrates that the second that a judge says you are discharged, that does not immediately and irrevocably render that person unfit for future service.
But if we look at the facts here, that person left the courthouse after being told that they were discharged to resume their life. And normally, you can speak to whomever you please or not. You can read what you want at that point. Isn't it risky to start saying, well, you were discharged, but maybe you might get a phone call?
If the judge had not gotten ample assurances, unequivocal assurances, in response to very detailed questioning on those exact subjects, then yes, we would have a
And
problem
it doesn't
here.
matter what the defendant thinks.
No, if the judge has discretion in this area, the judge asks them extensively whether they had discussed the case with anybody else,
So
whether
it's
they had
solely
formed
the
an
judge's call to undischarge a juror, is what you're saying?
Yes, judges have discretion as to how to handle these alternates.
And so that's the rule you would like us to adopt?
It's not a rule. It would be a matter of the judge providently exercising his or her discretion. And of course, it would be reviewable on appeal for abuse of discretion as well.
Doesn't your approach discourage punctiliousness by the judge, carefulness by the judge in deciding at what point in time to discharge?
No.
And as already been stated, the more we go down that road, the more you're going to have those kinds of opportunities.
This
Now it's a
approach,
few hours, the next case it's 24 hours. The next case is I went on vacation, I didn't discuss it with anyone because I wanted to forget everything that went on and I was gone for a month.
this case does not present that concern because in comparable situations in the future, a judge would not want to take the risk that, of course, an alternate immediately after being excused calls the office and says, I'm coming back, and can no longer return for service
Aren't we dealing
after
with an
that.
extraordinarily rare situation? I mean, does this really happen? Because you needed two things to happen in a very short period of time. You needed the judge to discharge the jurors before, discharge the alternates before charging the jury, which is not what the CPL says, right? And you need evidence sufficient to disqualify one of the seated jurors to show up in that little interstitial, basically at lunch, right, in this little period. Does this really happen?
This does not happen often, but there's a broader principle at stake here, and that is that trial judges need discretion to deal with the anomalous scheduling issues that constantly arise.
Trial judges, it's true, trial judges do need discretion, but this is not just a scheduling issue. This goes to the administration of justice and the defendant's right to have jurors that are suited at a particular point in time to render a decision on his or her case. It's not just the judge gets to decide we're going to adjourn before lunch, after lunch, or something of the like, or we'll resume after the holiday. This is much more substantial than that.
Well, right, but as long as we're talking about functional considerations, we should be able to consider whether this alternate was in fact able to serve fairly and impartially. And every answer to every question indicates that he was.
But this really goes back to Judge Rivera's question, I think, which is that if the rule is a bright line, that jurors discharged, that's it, won't all trial judges then wait until they've charged the seated jurors to discharge the alternates? Isn't that what will happen? Is that a bad thing?
Well, no, because these situations sometimes arise in circumstances that can't be anticipated. And the Brown case actually illustrates that point well. In the Brown case, what happened was that the judge did wait until the regular jurors were about to sit to deliberate, retire to deliberate, to discharge the alternates. And then before the alternates had actually left the courthouse, they left the room, I believe, but not the courthouse, they realized that one of the remaining jurors was no longer fit to serve, although deliberations had not yet, in fact, begun. And so at that point, they were able to call that person back, call the alternate back, and reconstitute the jury. And the point there was that there was no way that there was a miscarriage of justice in this situation. The interest of justice would have been in no way served by insisting upon a wasteful,
But
resource-intensive
here you're
retrial.
talking about someone actually leaving the courthouse and going home.
Yes, absolutely. And to Judge Wilson's point, their location does not necessarily affect their fitness to continue service. In fact, remaining in court for many alternate jurors would be a more problematic thing to do because
But what you emphasized on the other case was the timing of when things occurred. It was before the jury had begun to deliberate, and that juror had not left. Time does become important. The ability of that juror not to, or the fact that that juror continues to refrain from being tainted by being exposed, or even saying something like hello to a witness or a party, because part of the admonishments is you don't even want to give the appearance that you're not fair. So it becomes much more difficult in what you're asking us to do here is to not only not have a bright line, but to keep moving it the goalpost.
Well, just to be clear as to the timing matter, in that Brown case, it was another lunch break situation, so there was actually a significant interval time-wise between when the alternate was excused and when the alternate was reinstated. But to get to the other idea of the, sorry, I wanted to return quickly to one of the things that Judge Wilson touched on about the admonitions that are normally, or the timing of when alternate jurors are normally excused. There is no prohibition in the CPL for excusing alternate jurors at an earlier stage. It's not as though trial judges are required to
Of course,
excuse them
the
only
point-
when
the
they're...
point is that if the- Right, the point is if there is a bright line rule of the sort the council is asking for, judges wouldn't do that. They would, the statute says, after the jury has retired to deliberate, they would wait until the jury has retired to deliberate to discharge the alternates.
Yeah, well, and the
then
point
this
here...
problem could never occur.
Yes, well, it actually did occur in Brown, right? I mean, that's a situation where...
Well, then that may be Brown may not be correctly decided then, because it doesn't say once they start deliberating. The statute says after they've retired to deliberate, right? So
Well,
once
counsel-
they've retired to
But
deliberate.
aren't you, essentially, if I'm understanding you, even though you've said otherwise, you are essentially taking the position that a judge may rescind or reverse a discharge order. You may take the position there are very few circumstances under which they could do that, and that this is an example where they could do that, but this sounds to me like what you're arguing, that the statute doesn't prohibit that.
Yeah, our position is that when the judge utters the word discharge,
Yes.
the juror or alternate juror does not immediately and irrevocably become unavailable for future service. And that's exactly how this court has
Then what
interpreted.
does discharge mean?
Discharge does mean something. It means that the juror is excused, and of course, it may mean as a practical matter that the juror then does go make other plans.
So then should what the judge do say, you're discharged, thank you, but I might call you in 10 minutes, just so you know.
No, the judge need not do that because, of course, that's incredibly unlikely to occur. But in the off chance
Except
that
you've
it does
already
occur...
cited 2 cases where it has.
What's that? Sorry.
You're already talking about 2 cases where it has, right?
Yes,
Brown,
twice
this
over the
one,
last 20
so
years.
it happens.
But
That we know of, that got
in the off chance that that does occur, judges should be able to avoid a wasteful and resource-intensive mistrial. In this case in particular, you have 3 different defendants. You have more than a dozen witnesses. You have more than a week of trial
Well,
proceedings.
you might avoid that by waiting till the deliberative process,
Well,
right?
and if the information had come in, slightly later, right after the jurors had been discharged, the alternates had been discharged there, we'd have the same problem. The point is, judges need discretion to deal with these kinds of situations when
Yes,
they
but
do
there's a
arise.
statute for that if the deliberations have proceeded, right?
Yes, there is a bright line rule in that setting, but there's not a bright line rule that applies here.
Thank you, counsel.
I'd like to finish by giving Judge Renwick her due. She talks in her
pronouncing the name
dissent
correctly, thank you.
of the unfairness of having she used the word limbo, and that's really what respondent is advocating here, to tell somebody they're discharged and then keep them in limbo, that everybody in the courtroom, all the parties, the judge, the lawyers understand this person may be called back, but nobody lets the alternate juror know that they aren't really discharged.
So it could be arbitrary.
Right. So I just would urge the court not to
Well,
enable that
Yes, and you
situation.
certainly, for the reasons you've already stated, have the statute in many ways, the plain language of the statute on your side, because it talks about alternate jurors and discharged. I mean, these are 2 separate categories. You
Yes, Your Honor.
can't be in service when you are discharged.
What about if the alternate didn't know? So let's say the alternate doesn't show up, and you can, I think your adversary said discharge an alternate for other reasons. So the alternate doesn't show up one day, and the judge says the alternate didn't show up, it's discharged. The alternate walks into the courtroom.
Well, that, to some
That
extent, that's
limbo
getting
or
to
not
the de
limbo?
minimis, if you want, and then again, how far
It's not
down
de
the
minimis,
road are we
it's just
going?
different. It's, let's say, 10 minutes later, but the alternate never knew they were discharged, so they come back in.
There is a case with a regular juror where the judge, the trial judge, the appellate division thought that the juror had not shown up and discharged, and then somebody pointed out, well, no, the juror's here.
I guess the
And
point is, look, can you be in limbo if you don't know it?
I see your point. Maybe not. Okay. Thank you,
Thank
Your
you,
Honor.
counsel.